Sorry, that's us set up now, folks. There was a slight delay there. You can start if you want to start the meeting. Yeah.
Thank you. Good morning, everyone. It is 10 a.m. on Thursday, the 11th of May, 2023. Time to begin this pre-examination meeting for the proposed Strath Oykel wind farm, DPEA reference WIN-270-18. Before I proceed, can I check if everyone can see me and hear me? Yep, getting some nods and thumbs up. Thanks very much. During the meeting, it would be ideal if participants could please keep their cameras switched on, but mute their microphones except when speaking. This helps to ensure that people can hear what's being said. My name is Philip McLean. I'm a reporter with the Scottish Government's Planning and Environmental Appeals Division, or DPEA. I've been appointed jointly with Karen Haywood, Assistant Chief Reporter, to undertake the examination of this application submitted under Section 36 of the Electricity Act 1989, and Ms Haywood is also in the meeting today. The application is for a proposed 11-turbine wind farm. We will prepare a report to the Scottish Ministers on the application, and it will then be for them to decide whether or not to approve it. We will be taking a note of the matters discussed at the meeting as we go through, so do please bear with me if I need to pause for a moment to note something down, or if I don't notice someone trying to attract my attention just for a moment. A formal note of the meeting will be issued within a week after today. This meeting concerns the arrangements for any inquiry and associated procedures necessary to consider this case. It does not form part of the inquiry itself, and no evidence on the merits of the proposal will be heard today. We circulated the agenda just under 2 weeks ago. Hopefully everybody's seen that, and you've therefore had the opportunity to consider our current thinking. We'd hope to be able to progress quickly through the agenda, particularly on matters where parties are in agreement, and with discussion on matters where there are different views. A few initial housekeeping matters to run through. This meeting is being recorded and broadcast live, and Douglas Berry, who you've met already, a member of our IT team, will remain online in case of any technical difficulties. In due course, the recording will be available to view on our website. In accepting the invitation to this meeting, you have agreed to being recorded. I suspect parties are familiar with it, but anybody who isn't, this platform offers a grid view to allow you to see all parties participating, which you may find helpful. And as I mentioned, please mute your microphone when you're not speaking. We'll do our best to keep an eye on participants to watch for someone raising their hand or waving. Please do this if you want to attract our attention or to contribute at any time. If I miss you, please just do speak if you want to raise something. And please ensure mobile phones are on silent, please. I haven't planned any formal break in today's meeting, but I'll review matters in about an hour and see if a short break would be useful. So moving on to item 2 on the agenda, I'd now like to invite the lead participant for each party to introduce themselves and the members of their team, and also to indicate if they know at this stage if other witnesses will be involved in the process going forward. I'll start with the applicant, please.
Yes, good morning. So my name is David Hardy. I'm duly qualified barrister and solicitor, but for present purposes, I'm a partner at CMS. On the call, we've got Katie Nolan, whose camera is on. The client then is represented by Callum Morris. In terms of witnesses, there's David Bell dealing with planning matters. That's he's from David Bell Planning. And then Rebecca Rylett from WSP, who'll be dealing with landscape and visual matters.
Okay, thank you. Could you just spell Rebecca's last name for me, please?
Rylett is R-Y-L-O-T-T.
Okay, thank you. Thank you for that. Can I move on to the council, please?
Yes, so my pleasure. I appear on behalf of the council. My name is James Fingley, King's Counsel in Scotland and England and Wales. On the call today, we have Michael Cordis and Karen Lyons, And just to give advance warning for our visual objection, we have a visual rather than a landscape objection, which I'll say more about in a moment. I'm proposing to call Ian Kelly as a witness, but he's appearing this morning for other parties. So I'm dealing with Highland Council's representations this morning.
Okay, thank you. If we move on, please, to Mr. Kelly.
Good morning, sir. Thank you. I'm Ian Kelly of Ian Kelly Planning Consultancy Limited, and I appear for Noros, the local objector group. There's only myself participating in the call this morning. In terms of any additional witnesses, I will discuss that when we come to look at your thoughts on the community issues hearing session and my role in that session. But at the moment, there's just myself. Thank you.
Okay, thank you. And Dr. Williams, please.
Keith Williams, representing the Carlo Sutherland District Salmon Fishery Board and the Carlo Sutherland Fisheries Trust, and I'm here on my own.
Okay, thank you very much. I think that is everybody who is in the call. I am aware that as well as the parties participating today, there are other parties who have opted into the inquiry process who may be watching this meeting online, either live or at a later date. And I understand some, but not all of these parties are represented today by Mr. Kelly. All of these parties will receive the notes of the meeting and will be able to choose to participate in the subsequent stages of the inquiry process. It is worth highlighting that it can be beneficial and more efficient for parties with the same position on a topic to join together for that topic, and we would encourage parties who wish to participate in the inquiry process to consider whether there is scope for them to do this. This allows for the presentation of a coordinated case, avoids unnecessary duplication, and enables the pooling of resources. At this stage, are there any preliminary questions or issues to raise before we get fully underway? No? Okay. We will move on then to item 3 on the agenda, which some of you will be familiar with, but for the benefit of others, we'll just run through the code of practice for handling inquiries. There are no detailed procedural rules for the conduct of inquiries under the Electricity Act. However, DPEA has produced a code of practice which is modelled on the 2013 Planning Appeals Regulations. We expect to apply this code in this case. A link to the code was provided in the agenda for this meeting, and it is also available on the DPEA website. We'll also include another link to it in our note of this meeting. The code allows for flexible procedures, with each issue being dealt with by the most appropriate mode of examination. This could be an inquiry session, a hearing session, or further written submissions, and I'll say a bit more about them in a moment. On some issues, sufficient information will already have been submitted and no further procedures will be required. When we write the report to Scottish Ministers, we will take into account all the environmental information submitted by the applicant, all consultation responses, and all letters of representations already lodged. The type of procedure being followed, or the absence of any further procedure on a particular matter, is not an indication of the importance of that issue. So, for the benefit of parties who haven't been involved in anything like this before, including those watching online, I'll just take the opportunity to briefly explain the different procedures. In an inquiry session, each party will be invited to present evidence in turn, and this will be subject to cross-examination by those with an opposing view. Usually, parties are legally represented, and lawyers will do this cross-examination or questioning of the witnesses, although it is not essential to have a lawyer. Ms. Haywood and myself will also have questions. Inquiry sessions are more formal than hearing sessions and are particularly suited to topics where there's a lot of technical evidence. A hearing session is a structured discussion led by reporters based on an agenda which we will issue in advance. There is no formal leading of evidence or cross-examination. Parties' lawyers can take part in the discussion, but there's no need for legal representation. Hearings are generally less formal than inquiry sessions and are suited to issues where there are differences of opinion of a less technical nature. Further written submissions are simply us as reporters asking parties to provide certain information and inviting other parties to comment on that. Site visits are also part of our evidence gathering, and we'll discuss these later in the meeting. All parties that wish to be involved in the inquiry or hearing sessions should understand they will need to prepare and submit their case in advance to allow other parties to see what evidence is being presented and to avoid any surprises on the day. You'll see in the agenda and its appendices that we have already set out how we think the case should proceed, and we'll discuss this in more detail later in the meeting. But before I move on, are there any general queries on the Code of Practice and the options that it offers? No, everybody happy? Okay, in that case, we will move on to item 4 on the agenda, which relates to any updates to parties' positions and any additional information that may be necessary to update the application. In addition to the bullet point raised on the agenda, which we'll come to in a moment, there's another matter that I wanted to raise at this stage, having reviewed the application further, which is whether the applicant is still to provide a response to matters raised regarding peat in the stage 2 checking report by Ironside-Farrer. There's some correspondence on the application regarding that.
Yeah, we have provided that. It's was sent to the ECU a few weeks ago, and the ECU would send it across to yourselves. We are, however, still waiting the final response from Ironside-Farrer on the matter.
Okay, thank you. My next question was about the timescale for this. Obviously, I wouldn't expect you to know the timescale for Ironside-Farrer, but you have responded and provided your information. Okay,
Yeah,
that's
correct.
fine. We'll hopefully get sight of that soon. Also, in relation to peat, I'd like to just clarify the position in respect of comments made by SEPA in its consultation response. We note that its non-objection is conditional on the proposed location of the substation, battery storage and construction compound being amended in accordance with a drawing produced by the applicant. We'll discuss procedures in more detail later, but I'd just like to get parties' views on how we should address this issue and whether we might need further written submissions to cover that. I'll start with the applicant, please.
Alan, do you want to pick that up as well?
Yes, as you say, we agreed that there would be no objection from SEPA subject to the relocation of that. Happy to discuss how we change that position in terms of the plan. Let's say the additional plan was submitted as part of the application to Highland Council at the time.
Do any other parties have views or comments on that, Council?
No comments from us, I don't think.
Any other parties have comments on that stage? Okay, something that Ms Haywood and I can consider, and we might come back to it later on the agenda, whether we feel we need to seek any further information on that. Returning to the point that is noted on the agenda, we suggest there is likely to be a need for an updated cumulative landscape and visual impact assessment that takes into account any other new wind farm proposals at application or scoping stage, or any change in status of any proposals. Could I ask, please, for the views of the parties on that, starting with the applicant again?
Yes, we don't respectfully think there is a need for an update. We think that the position, as stated in the EIAR, remains sound. If you want a little bit more detail on that, I think within 20 kilometres there is one new application. That's for Clean Save, But that is Norfolk Leg, and there are existing wind farms and consented wind farms which are in between. So we can't see that would justify an update outside of the 20 kilometres. They're within the CLVIA already. I think there is one new application out with 20 kilometres. That's the Strath Oykel redesign. But our view is that that is a de minimis contribution to the cumulative visual impact. So our view is not required for those detailed reasons.
Okay, thank you for that. Does the council have any comments on that?
I don't believe we consider one is required, although I understand Mr. Kelly may have a point about application for an electric line that's passing close by the site.
Okay, Mr. Kelly, can I bring you in now?
Yes, sir. On the cumulative effects, SSE and transmission are consulting on a major new overhead grid line going from Spittal in Caithness to Loch Buie, crossing the Kyle of Sutherland to the east of the application site and then proceeding to Beaulieu. My original thought was that that should be included in an updated cumulative assessment, the landscape and visual assessment, whilst recognising that SSCEN at the moment are still consulting on route options. But if you were to agree, sir, that no updated landscape and visual impact assessment is required in terms of wind farms, then I would not insist on anything to be done solely because of this overhead line. So had there been an update, I would have wanted to see the line included. If you are agreeing, sir, that there is to be no updated landscape and visual assessment based on wind farms, then I would not ask for this an update to be done solely for the line. Thank you.
Okay, thank you. You've taken a note of that. We'll consider that. Does any other party want to comment further on that matter? No. Okay. Thank you for your input on that. We will confirm our views on that in the notes of the meeting. Before we move on, I also just wanted to highlight that National Planning Framework 4, NPF 4, and Onshore Wind Policy Statement have both been published in recent months. The application has already been updated by the applicant in respect of NPF 4, possibly not the onshore wind policy statement. We would expect statements for any policy hearing session to address the up-to-date position. Before we move on from this agenda item, do parties have any other views on any other updates that we may require? No.
From our side, thank you.
Okay. Thank you very much. In which case, we will move on to item 5, which is our provisional assessment of the main issues to be addressed and those requiring further procedure. So Appendix 1 of the agenda sets out our initial views on the topics to be addressed in our report and our proposed methodology for dealing with each subject area. There have been no significant changes in our views since the agenda was issued, except that we may be giving further consideration to peat and how to deal with the responses from Ironside, Farrer and SEPA, as we discussed under the last agenda item. I'll run through our suggested topics and seek comments. Just to be clear, on this agenda item, I'm not looking to establish who wishes to take part in each session, and we'll move on to talk about that under the next agenda item, just looking to establish the procedures at this stage. So in terms of inquiry sessions, we have suggested that landscape and visual impacts should be addressed through an inquiry process. We understand that visual impacts are the basis of the Council's objection, although it would be helpful to us if the parties could also set out the landscape context for their positions, and we outlined in Appendix 2 the likely matters to be considered. I know there was a comment earlier about the visual versus landscape issue, which we'll no doubt come on to. So I would like to invite comments, please, on whether the parties agree that this is the right approach to considering landscape and visual impacts. I'll start with the applicant, please.
Yes, we're happy with an inquiry session. I mean, I don't know whether you want to go into details now, or I could probably simply just to open up the discussion. We've got a question mark over the request for clarification on quality visualization. We were a bit puzzled by that, and wanted to know exactly what was being asked. Secondly, I think clarification as to why wildland areas are included, given the absence of nature scope. Obviously, people will be aware of the position that it's taken post NPF4 and the policy statement in relation to wildland. And then thirdly, in relation to aviation lighting, it feels to us that that's better dealt with by way of further written submissions. We don't think it does need to be part of the inquiry section. So yes, to the type of procedure, but subject to those 3 points.
Okay, I'll just clarify, if I may, before moving on. The point about quality visualizations, this was a very preliminary list of potential topics, so that's not in itself intended as a comment on the visualizations. Just a topic that parties
so
may...
a potential topic, but to understand that, it'll be interesting to hear that I'm not aware of anybody saying that they are substandard. We certainly don't think they are, but it would be helpful just to get clarification on that.
That's maybe something parties can pick up in a moment when I turn to other parties. In terms of wildland areas, again, parties may, if we do, and we'll move on to how we address policy matters, but obviously if there are positions in respect of the relevance or otherwise of wildland areas, we'll pick that up. Again, this is a potential list of issues to cover. And I've noted your comment in relation to aviation lighting, and we can come back to that and take the views of other parties. Can I move on, please, to the views of the council?
So, in terms of having a session on landscape and visual, agreed. Whether it needs to be an inquiry, Highland Council regularly suggests that hearing sessions can be just as, if not more effective, but that's ultimately a matter for you. I can make further submissions about that if needed. As far as I'm aware, we have no issue on quality of visualizations and selected viewpoints. To reassert the point I made earlier, Highland Council's objection is a visual impact objection. Now, it may be necessary to provide some background landscape evidence, but it is not a landscape character objection, and it's certainly not a wildland area objection. So hopefully that may help Mr. Hardy and his witness. And then in aviation, subject to being informed otherwise, it seems to be a sensible point that can be dealt with by writing, certainly from the Highland Council's viewpoint. The other matters are all don't require comment.
Okay, thank you for that. That's useful. Can I turn to the other parties, please? Can I start with Mr. Kelly?
In many respects, my comments really must be kind of seen in the context of still to decide how Norris takes part in the evidence sessions. At the moment, Norris did object on wildland grounds and have been considering how best to deal with that, including looking for an update on the nature scope position and dealing with it in the policy evidence. But as matters stand, Norris would not have a separate witness at the inquiry session. Norros would be looking to follow up its objections on landscape and visual grounds, either by a written submission or by a full participation in the community issues session that you've suggested, sir. So if I keep it as simple as possible, Norros do not intend to have a witness in a landscape and visual inquiry session.
Okay, thank you. That's noted. Dr. Williams, do you have any comments on this matter?
No, none at all.
Okay, that's fine. Are there any other comments, given what's been said? Does anybody want to come back on anything that's been said before we move on from landscape and visual inquiry? No. Okay, thank you very much. That's useful. We'll move on to the issues that we have suggested should be subject to hearings. Firstly, we have suggested a hearing session to discuss applicable energy and planning policy and its implications for the proposal. Are parties happy with this approach, or if not, can I invite any comments, please?
From our side, yes, happy.
Any other comments?
No, council's happy. And just to say, our witness on this will be Michael Cordus.
Norros are happy with a hearing session as well. The witness would be myself.
Okay, thank you. Just noting all that down. That's great. We'll move on now to our suggested hearing session focused on the matters raised by the local community, including Crete Community Council, the Norros Group and other parties. These matters include residential amenity, the local road network, the tourism economy, local employment and cumulative impacts. Want to ask whether parties are happy with this approach and have comments, and also if parties have views on, if we do proceed with a session of this nature, how it might best be run, the scope of matters that it might need to cover. I think, can I start with the applicant again, please, just for consistency?
Yes, I mean, happy in principle. We're going to discuss timing later on, but one question we got was whether or not there might be an evening session into the issues. Just to sketch out the sort of timetable, I think Mr. Finlay offline had suggested that L&B might take 2 days, so Tuesday and Wednesday. And one thought was that the policy, I think, half a day. So that leaves that on the Thursday, you might have a bit of a break and then an evening session to deal with the community issues on the Thursday. I think there are pros and cons to evening sessions, but I think my general view is that the pros probably outweigh the cons. People being at work and so on, it makes accessibility easier for people who are out in the workplace. So in principle, yes. I'm easy about whether or not that is in the afternoon or an evening, but an evening session seems to be a good idea.
Okay, we'll come to Mr. Kelly in a moment and the views of Norros. Just before we do, can I just ask if the council has anything to add on this one?
No, but not particularly. We're very happy to support an evening or other session, but it's not a session that the council would be taking part in. They may have a watching brief. At least that's, I understand, the way these sessions have worked in the past. As to timetable, yes, having discussed it further this morning, our view is that landscape and visual is likely to take perhaps a day and a half, at most 2 days. So, and I agree that policy hearing is unlikely to take more than half a day. There's a condition session which might hopefully not take very long, and so there would be scope for having the community session either late afternoon or evening of the Thursday. with potentially perhaps the accompanied site view on the Friday. I know that's slightly jumping ahead, but it may help frame others' submissions if I make that clear now. And I see Mr. Hardy.
Yes, I'm very grateful for that, Mr. Finney. I agree.
Okay, that's useful. Yeah, we will discuss timetabling in more detail shortly, but I think that's helpful. I think I'll come to you in a second, Mr. Kelly. I think in terms of, I suppose, whether an evening would be a suitable way of doing it, it may depend on the range and scope of the issues that we need to cover in that session, and whether an evening will be enough time. Can I bring you in, please, Mr. Kelly?
If I may, just to add something, if I don't disagree with this, if in fact L&D is going to be sort of a day and a half to two, there's a possibility of the Wednesday night. So actually, community session could be the Wednesday rather than the Thursday. That's got the benefit that if people can't make the evening session on the Wednesday, there might be time on the Thursday for some overspill. So that opens up that possibility as well.
Okay, that's noted. We'll probably discuss this in a bit more detail shortly. Mr. Kelly, your thoughts, please.
The preference would be an evening session, if at all possible, even with an early start. If, for example, much of Thursday was free, then we could maybe start at 5 o'clock or 4 o'clock or something to fit in and have a break during the evening session. In terms of the issues, a bit like Mr. Finlay said, in terms of the Highland Council's visual objection, you have residential visual amenity listed as a topic. There is a landscape background to that would be covered in comments, but it would then focus on residential visual amenity. In relation to this session, can I ask, do you see the professional witnesses taking part and contributing, or do you see it only being the local people themselves contributing?
I mean, I suppose we'll come on in a moment to participation and who would want to participate. I'm just mindful of the amount of time that we would have in an evening session, but I'm also mindful of if there are points being raised by parties, whether the applicant would wish to have the opportunity to respond to that and have witnesses present. It might be helpful just to get your views, Mr. Kelly, on which topics in particular you think this session might need to focus on. There's 4 bullet points noted down in Appendix 2 of the agenda. That's potentially quite broad ranging. Do you think that is the appropriate scope of topics? Could we narrow it down? Is there anything missing? Just interested in views on that, which might inform how much time we actually need for this session.
Residential visual amenity will be one of the main concerns. The effect on the local road network, the narrow single track road, is a concern. There are issues around the proposed new bridge. The issues on tourism primarily relate to the potential effects on the River Oykel SAC and the consequences of that, rather than being a separate topic. So I think that would probably be better covered under the implications of the effects on the River Oykel. Noise, there already are noise issues in the locality from Rose Hall and the Canning wind farms. Here, we really wanted to see what the Highland Council's position is. I think I would be perfectly happy if noise was addressed under the conditions session, rather than being taken as a community topic. I mean, it won't really help your consideration just to have several people standing up and saying, well, I can hear a wind farm already. We need to see how the matter would be controlled. So I think noise can go to the conditions session. Shadow flicker, I haven't seen any specific mention of shadow flicker from anybody. I'd need to check the calculations in the EIA, but I think you can assume that residential visual amenity, the local road network, will be the main topics that people would talk about. In relation to participation, there were a wide range of landscape issues raised in the NOROS objection. If you wish to restrict this evening session or afternoon evening session to local people only, then I think it would be helpful if I prepared a written submission on NOROS's position on landscape and visual, and that would then give the applicants a chance to respond to that before the evening session. The final comment on the evening session, and it relates to how these have been run in the past. Sir, would you be expecting those who wish to speak to prepare a short statement or submit a short statement in advance? Again, if you did, sir, I would take responsibility for coordinating that, but it's a decision for yourself, sir.
Yeah, that point is the next question that I have in my notes here. I think there are potentially benefits. Obviously, the nature of the process is geared up that with prior disclosure of the cases. Do any other parties have strong views on that for us to take into account as we consider that particular point on the need for statements in advance of a hearing session?
Yes, I mean, a number of points in response. I think the evening sessions vary in my experience. I think the best ones are those where members of the local community feel free to express concerns, and they go and they're taken in that light, so they're not subjected to formal cross-examination. And if there are any technical points, then they can be responded to in writing. I think you get into difficulty if you start having a sort of hybrid session where there is cross-examination and evidence becomes more formal in nature. So my suggestion would be for that to be for local people, for local issues. The scope of that, I don't mind, but the character of it is that. In terms of witnesses, we would want to deal with all landscape and visual issues in the L&B written material and in the evidence session that Rebecca Rylott will be attending. She may be in attendance. I suspect she would be at the evening session, but I think that's the clear thing rather than in any other capacity. Certainly not expecting for her to give evidence on residential amenity on. In terms of prior disclosure, yes, I wouldn't. I heard Mr. Kelly. I think the only thing that I didn't agree with was that a written statement setting out the landscape methods would be available prior to the hearing. I think that's too late. We'd like to see that, and therefore Ms. Rylott would be able to deal with that in her written evidence and evidence in the L&D section. So if there are going to be statements, prior disclosure, but particularly that relating to the more general landscape case that the more honest would want to know.
Okay, thank you. Just taking a note of those comments.
The final point probably just is this, that in relation to residential amenity, of course, the best thing is you could have a list of properties that you're going to go and have a look. So to hear the evidence in the session, and then that can be coupled with the site visit, you've got those notes the following day or whenever it is. Yeah,
we'll come on to site inspections in a moment, and we may well pick that point up. Just conscious, Dr. Williams, I don't know if you have any comments on this, not wishing to exclude you from this topic.
Just thank you. Just for clarity, one of the other hats I wear is I'm currently the chairman of Creek Community Council. So I'll just point that out to everybody. Obviously, I'm here today not to represent Creek Community Council, but Kyle Sutherland Fishery Board. But I just like everybody to be aware of that for clarity. And obviously, I recall that Creek Community Council has put submissions in about this subject, and of course may do so, may take part in the sessions in some form. If it does, I would try and make sure it was somebody else to avoid confusion, and for me to remember which hat I'm wearing at any given moment.
Okay, thank you. Are there any other comments? I think we've heard their potential means to slightly narrow the focus of what might be covered in that session, and we've heard thoughts on the need for statements in advance or not. Ms. Haywood.
Just a point of clarification for Mr. Kelly. You have read, and also Mr. Hardy mentioned it too. You talked, Mr. Kelly, about setting out Norris's concerns about landscape and visual issues in a statement. And you mentioned it in relation to the hearing, but Mr. Hardy was saying he wanted to have that for Mr. Ryland to address as part of the inquiry session. Mr. Hardy, is that what you meant?
Yes, it was to avoid sort of a note coming the day before the community session, which then dealt with a substantive landscape case. That's the concern I've got.
Okay, but Mr. Kelly, so what was it you had in mind?
I fully accept Mr. Hardy's point. I would have suggested that the written submission from Norris and Landscape and Visual should come in with the inquiry reports on hearing statements, which was 4 weeks before the inquiry. If you wanted it slightly earlier than that, that's fine. But certainly I accept Mr. Hardy's point that that has to be there so that Ms. Rylett can consider it. So I would have suggested at the same time as the hearing reports or inquiry reports, or earlier if you wish. But okay, certainly no last minute submissions at all. I fully agree with Mr. Hardy.
Thank you, Mr. Kelly. Thank you.
Okay, thank you. Any other comments on the community issues session? Anything we've not covered that anyone wants to raise before we move on? No. Okay, thank you very much. So moving on to our next proposed session, which would be a hearing session to cover draft conditions. As set out in Appendix 2 of the agenda, we propose that the applicant should liaise with the Council and any other relevant parties to prepare a set of draft conditions. We're aware that there are conditions included in the Council's committee reports. We can discuss the timeframe for this under item 8, but at this stage it'd be useful for us to know if there's been any progress so far on agreeing conditions, and are the parties content with this suggested approach of preparing these in advance and discussing in a hearing if agreement is not reached. Starting with the applicant, please.
Yes, absolutely. We don't expect that to be a stumbling block with lots of experience with conditions. I think there's always a few bespoke conditions, but the general boilerplate conditions are well trodden. So we will work with the Council in advance. Anything that's left over, we will prepare a schedule of agreement and disagreement. Hopefully that will be limited in scope, and I don't expect the hearing sessions to take very long.
Okay, thank you. Any comments from the Council, please?
No, I mean, obviously it'd be helpful if the starting point could be our conditions that you've referred to, but yes, I don't anticipate any significant issues arising. If there are, they can be refined so that the hearing session concentrates on them.
Any other parties wish to comment, Mr. Kelly?
Yes, sir. Norris would wish to be included in the correspondence and exchanges on conditions and take part in the discussion. Noise will be one of the issues I think we end up discussing, and the road conditions relating to road. But basically, if Norris are involved, then we'll participate and again try to narrow down the areas of disagreement in accordance with your wishes.
Okay, and Dr. Williams, any comments from you?
No, thanks.
Okay, thank you very much. That's helpful. We will move on then to our proposed topics for further written submissions. As set out in Appendix 1 of the agenda, we suggest that ecology issues relating to fisheries and the River Oykel Special Area of Conservation, or SAC, could potentially be addressed through the use of further written submissions. As explained in Appendix 2 of the agenda, we believe that this could focus on the comments set out in the consultation response from the Kyle of Sutherland District Salmon Fishery Board, including impacts on water quality and fish migration. Having reviewed the application further since the agenda was prepared, we also consider it would be helpful for these submissions to address the position of NatureScot set out in its consultation response, that if the application is approved, an appropriate assessment of the proposal's impact on the SAC will be needed under the habitats regulations. Our report will need to contain sufficient information to enable ministers to undertake an appropriate assessment if they wish to approve the application. Just to be clear, this does not prejudge our conclusions nor the decision that ministers will take as a standard part of the process, but it doesn't appear that the EIA report addresses this matter, and we therefore consider that a draft appropriate assessment should be provided by the applicant in standalone format so that we can cover this in our report. We would then seek NatureScot's comments on this document, as well as those of parties already participating in the process. So I'd just like to open that out to comment, please, starting with the applicant.
Yes, grateful for that. And yes, we will do what you asked. So if that's required, we will do it. I think in terms of written procedure, yes, in relation to fisheries and the impact from the SAC.
Okay, thank you. Any other parties have comments on that? Seeing shaking head from the council. Dr. Williams, obviously we're talking about your objection. Can I bring you in, please?
Yes, I'm increasingly concerned about the ecology of the River Oykel, in fact all our rivers locally. I'm very concerned as well about some of the EIA processes and their ability to protect the aquatic environment. So I wondered if it would benefit from a hearing session rather than written submissions. I wonder if that could be considered.
That's certainly something that we can go away and look at. I'd like to hear the views of the other parties on that suggestion, please.
Yeah, well, we don't think that's required. We think written submissions is the proportionate way to go. Obviously, they're serious matters, but they're ones which can be set out fully in writing. So we're not taking away from the importance, but written procedure will be sufficient.
Any views from the other parties, council? Mr. Kelly?
Norris would support the holding of a hearing. We think there are matters that would benefit from debate in front of you in terms of the environmental impact assessment and responses to it, but largely because of the significance of the risk. I mean, the whole basis of the valley's economy is the river, and therefore we think that it should be, we would support Dr. Williams in seeking a hearing session. And obviously it's your decision, sir, but Norris would certainly support a hearing session.
Okay, thank you. That's noted. The note of this meeting will confirm what our view is on that, but we'll certainly note what's been said. Any other comments on that matter? No. Okay. In terms of written submissions, as mentioned earlier, we have been also considering whether we may need to address matters relating to peat through further written submissions. So we will come to a view on that based on discussions. Is there any other points to raise on the question of peat at this point, or have we covered that sufficiently earlier on? Everyone happy on that point? Okay. Moving on then to the topics where we're not proposing any further procedure. You'll see at Appendix 1 of the agenda that we believe that a number of issues can be addressed without further procedure, and we will consider in detail the information that has already been submitted on those topics and issues. I'll briefly run through the list of topics, and then if there are any contrary views on any of them, we can discuss. But they are ornithology and ecology matters, not including the River Oykel SAC and fisheries, as we've already discussed, hydrology and geology, not including peat, cultural heritage and archaeology, forestry, aviation issues, including lighting and radar, by which I mean aviation safety as opposed to any visual issues, and telecommunications. Do any parties have any comments on these matters being subject to no further procedure? Mr. Kelly, I can see your hand up.
I obviously need to be careful not to stray into evidence, but just for your information, sir, there are ongoing and very successful habitat restoration schemes in Strath Oykel just now, and they have been further progressed to the north in Glencastley. One of the positive benefits from these habitat restoration schemes has been increased raptor activity in the area. Now, obviously, this postdates the completion of the environmental impact assessment work. I'm not sure how you might want to get some more information on this. It may be that you could seek an update from Nature Scott that everybody could comment on. But I just wish to draw to your attention that there is a rapidly changing situation because of the extensive habitat restoration work currently underway, both in Strath Oykel and in the immediate valley to the north at Glencastley. Thank you.
Okay, that's noted. Do any of the other parties have any immediate comments on that? That's something we can take away and consider in that case. Are there any other comments on any of the topics that I ran through a moment ago? No. Okay, thank you very much. We'll come on in a moment to discuss which procedures the parties wish to be involved in, although we've probably touched on some of that already. Just before we move on, are there any other significant issues that have been raised in representations that we will need to address in our report, but that we haven't discussed or mentioned so far? No. Okay, thank you very much. We'll move on then to item 6 on the agenda, which is to discuss which topic areas parties wish to give evidence on, inquiry, hearings and further written submissions. I would have assumed the applicant and council would participate in all procedures, although I note the comment that was made earlier about the community hearing, so I've taken a note of that already. As mentioned earlier, we are aware that there are a number of parties who have opted into the process but who are not attending today's meeting, including Creek Community Council and several individuals. When the note of today's meeting is issued, all parties who have opted in will be invited to confirm within 14 days whether they intend to participate in the proposed inquiry or hearing sessions. And I would remind parties that we would strongly encourage them to join together with other parties who have the same point of view on a particular topic. As also mentioned earlier, a reminder that all parties who wish to be involved in hearing or inquiry sessions will need to prepare and submit their case in advance to allow other parties to see what evidence is being presented and to avoid any surprises on the day. Obviously, we had a discussion earlier about the extent to which that should apply to a community hearing session, so we will pick that up in our note of the meeting. For the inquiry session, parties will need to submit precognitions and or an inquiry report in advance at the appropriate stage of the process. We'll talk about dates a bit later. We do not expect inquiry statements to be submitted. It's also important to be aware that parties should be prepared to take questions on their evidence from the lawyers or representatives of other parties. So I think based on the discussion already, the applicant and the council and Noros wish to attend this inquiry session. Can Dr. Williams confirm if the Fishery Board would wish to take part in this session?
Oh, don't wish to, thanks.
Okay. Other than coming on to dates, which we'll do shortly, are there any other questions regarding the inquiry session? Okay. Moving on to hearings. As discussed earlier, a hearing would be a structured discussion that Ms Haywood and I would chair. We propose that the first hearing topic would be on energy and planning policy. We'd anticipate the applicant and the council would wish to take part. Would Noros wish to take part?
Yes, sir. Thank you.
Yeah. And Dr. Williams, would the Fishery Board wish to take part?
No.
No. Okay, thank you. So the second proposed hearing session would be a community issues session. I won't run back through the items that will cover. I think we've discussed that. As mentioned earlier, we will seek confirmation of whether opted-in parties not attending today's meeting also wish to take part, including Creek Community Council and other individuals. And we've touched on the fact that this could potentially take place in the evening if this would best enable parties to participate and would allow sufficient time. So I noted that the council may not wish to participate in this session other than to observe. I assume the applicant would wish to take part, is that correct?
Yes.
And Noros obviously would wish to take part. And Dr. Williams, would the Salmon Fishery Board wish to take part in this session?
No, I don't think that would be appropriate, thanks.
Okay, thank you. The third proposed hearing would be on the draft conditions. Just to be clear, if I've not already made it clear, that this doesn't prejudge our conclusions nor the decision ministers will take, but it is a standard part of the process to consider the conditions that should be attached in the event of approval. And our report to ministers will need to address this. I think we've already covered the fact that the applicant and the council and Noros would wish to take part in that session. Dr. Williams, again, turning to you, would you like to take part?
I think actually this one, it might be useful to take part in this one. Thank you.
Okay, that's fine. We touched on, and again, we will sort of confirm our view on this in the note of the meeting. If there were to be a hearing session in relation to fisheries matters, I assume the applicant, the council, and certainly the fisheries board would wish to take part. Would Noros, given the comments you made earlier, I assume Noros would also wish to take part?
Yes, sir. Noros would wish to take part. We'd need to give some thoughts to whether a hearing statement would be required. Noros would want to be there primarily to answer any questions that you may have of them or to pick up any point of detail. But if it was considered helpful in terms of prior disclosure, then we could prepare a short statement to assist, sir.
Okay.
Same point arises about prior disclosure. Look at anything that's in writing to be given in advance.
Okay. That's fine. We'll move on. Correct me if I'm wrong. I don't think we discussed any other possible hearings, in which case we will move on to further written submissions. Can I just clarify, and I think we've probably covered this, and I note the comments made in relation to ornithology. Are there any final comments that parties want to make on whether there's any other further written submissions that we might need to seek from other parties?
No, not.
Okay. Now, I did say that I'd review matters in terms of a break after an hour. It has just gone 11 o'clock. We're reasonably well through the agenda. Are all parties happy to continue at this stage?
Let's carry on, yeah. We're happy, yeah.
Yeah, okay, that's fine. So we have already touched on this a little bit. Item 7 on the agenda is the dates, the format, location, duration of hearing and inquiry sessions. Starting with format, we have suggested that sessions are held in person due to the level of local public interest. We are aware that there is one opted-in party who's not participating today, who has indicated they wish to participate in the process but may be unable to attend in person. So for any relevant sessions, we may therefore also consider the potential for that party to participate remotely with other parties in the room. We'd also intend that if possible, sessions would be webcast. This would enable other parties who are not present at the sessions to view them online and follow what's going on. So subject to any reasonable adjustments to enable remote participation where necessary, do the parties agree that in-person inquiry and hearing sessions would be most appropriate? Any comments on that, please? I'll start with the applicant again.
Yes, that's agreed. I think subject to making sure that the hearing session, if there's an additional one in relation to fisheries, is timetabled for that week. What we wouldn't want to do is spill into a second week. If that was required, I don't know if we need to do that, but if that was required, then we'd be suggesting that that was dealt with virtually. But I think we can deal with all of these in person in that first. So, sure, yes.
Yeah, okay, thank you. Any other comments, Council?
Happy with that.
Yeah, Mr. Kelly, Dr. Williams, happy with that approach?
Yes, happy with that, yes.
Yeah, that's fine. So for in-person sessions, we will need to decide a suitable venue in the local area. I don't know if that's something that anybody's able to offer any comments on at this stage.
I think the answer, we've started to look at that, but all contributions gratefully received, I think is the instruction. So
I think I saw Mr. Kelly's hand go up.
Yeah, yes, sir. Thank you, sir. The suggestion would be Rose Hall, Village Hall, very close to the site and in the community. The main room can take up to 100 people, and there's some ante-rooms. There's good parking outside, providing we're not there at 9 o'clock in the morning when the local primary school goes in, but that shouldn't be an issue. The one matter I have asked be checked up on, and I've not had a response yet, is the capacity of the Wi-Fi at the venue to ensure that you can do webcasting of the inquiry, as well as us being able to access documents. So subject to my getting information on the Wi-Fi capabilities, I would suggest Rose Hall.
I think the difficulty there, Mr. Garrett, actually on that point, my instructions are that Rose Hall doesn't have good Wi-Fi. My specific instruction was that the council confirmed that it doesn't have internet access at all. So that is a major problem. And recently I've been involved in some inquiries and hearing sessions where, or hybrid sessions where internet access has been required, and when it's failed, it's caused a major problem. So probably best to have that discussion now. So yes, yeah, location-wise, absolutely agree. I think that's super. But practically, because of the absence of Wi-Fi, in particular, if we're going to have some hybrid sessions, there's a real concern.
Okay, that's all noted and is useful, and certainly something that we look into, but certainly internet access is likely to be required. Are there any other potential venues that we should be considering at this stage?
So, sir, before Eamon says anything on that, on the Wi-Fi access, what I will do is I will try and get a firm answer from the local management committee within the next day or two, and so that you can then have a definitive answer before you issue your note of the meeting.
I think that'd be very helpful, Mr. Kelly. All I would say is that the pressure that gets put on Wi-Fi infrastructure can be quite great in these situations. And in fact, the example I gave was in a hotel, and you'd think that a hotel had, and a wedding venue would have good Wi-Fi, and it said it did, but when 15 people get in the room and they all want to get online, the thing collapsed. So it's not just a case of having some Wi-Fi, it's having the infrastructure capable of supporting 12 or 15 people with laptops and trying to stream things, which is quite heavy.
Yeah. Dr. Williams, I can see you want to come in at this point.
Another potential venue for Rose Hall isn't suitable is Bonar Bridge Village Hall, which is also a good hall. The Wi-Fi within Bonar Bridge is usually pretty reliable and pretty good, and it's still within the parish of Creek, where Rose Hall is situated. So that might be an alternative venue.
I think that the instructions I've got is the council had raised that as a possibility. I think on the basis that Wi-Fi might be better. Other suggestions I think were Leg or Ardgate. And all we want to do, we want to have a suitable venue that is accessible and is proximate to the site, absolutely, but subject to functioning properly and not getting there and not, and then running into difficulties.
Okay, that's useful. Any updates on the internet position at Rose Hall will be useful, and we can certainly look at the other suggestions. So moving on, we'll come to dates in just a moment, but I'd just like to establish first the parties' views on how much time we should set aside. There's been a few comments on that already, and obviously there's been requests for an additional hearing session that we'll need to consider. We had thought that perhaps landscape and visual might require a day, but I've heard comments earlier in the meeting that a day and a half to 2 days is what the applicant and the council consider we might need. Is that correct?
Yes, but if we took the midpoint of that, if we said a day and a half, so on the Wednesday we could have any of the other hearing sessions, and I raised earlier the possibility of having a community session on the Wednesday night, just in case there was any overspill, and then the other 2 sessions on the Thursday morning and the Thursday afternoon respectively. So I think 3 days will, Tuesday to Thursday inclusive, will be sufficient.
Okay, are there any other views on that? Obviously it will come down to the final choice of sessions, but just coming back to how many hours we should allow for the community hearing, if that is to be in the afternoon or evening, what sort of time scale based on experience do parties think we should be allowing for that?
Don't know how many people, do you know, Mr. K, roughly how many people might be wanting to not just attend but to speak?
At the moment, I don't know the exact number. I imagine it would be less than a dozen. I think you could, I would say 2 hours, allocate 2 hours, but I would certainly not envisage it going beyond 3 hours. No. Right. So less than 3 hours.
Well, if you said 2.5, 7 till 9:30, something like that, that sounds.
If you allocated 2.5 hours, I think that would be perfectly adequate, and people would, of course, fit in with that. So 2.5 hours. On the timetable, sir, just when I'm speaking, I had assumed you were going to start on the Monday, but is it your intention to start on the Tuesday?
Our intention provisionally would be to start on the Tuesday. Obviously, certain parties will be travelling some distance, so that would allow the Monday for that.
I can't get up. It's got to be the Tuesday, because just in terms of flight. So Tuesday would, and I don't think, given the timetable, that poses a threat to finishing anyway. I think Tuesday through Thursday we'll see this done.
Yeah. Okay. Are there any other? We'll come to the dates themselves in just a second. Just in terms of sort of time scale, there seems to be tentative agreement that around 3 days is sufficient. Is that fair reflection of parties' views at this stage? This is subject to consideration of an additional hearing session that has been put to us. Any other comments on that? And we'll move on to the dates then, which we've sort of come on to really. So
just in terms of, just if it makes sense, in terms of running order, I would have thought that LNV, then fisheries, then the policy session, and then the condition section, that would seem to me to be and then with the community hearing either on the Wednesday or the Thursday night. I'd have thought it's the sensible running order, Mr. Finlay. I don't know you.
Just, I suppose, just
thumbs up from Mr. Finlay. So that's Mr. Kelly. I don't know.
Certainly happy to hear comments on the timetabling. We'll go away and come up with our version of that. But yeah, thoughts on that are welcome.
Sometimes it's valuable to have a break before the community session, gather our thoughts. My preference would be if the community session was timetabled on the Thursday night. In terms of having the fishing session, hearing session after landscape and visual, yes, that's fine, because then it can feed into policy and condition considerations. Yeah. Rather than finding that we take fisheries at the end and suddenly realise there's a policy issue or a condition.
Yes, that's what I was. That's what I was thinking, Mr. Kelly. So yeah,
agreed with that.
It's fine. Just in terms of the dates themselves, which we haven't actually touched on, I understand we've proposed sessions during the week commencing 23rd of October, and we understand the applicant and the council can accommodate that, other than the Friday in the council's case, I understand. But just to confirm that is the case, and the other parties can also make that week.
Yes, the 24th, Tuesday the 24th, 25th and 26th, yeah.
Yeah, that's okay for the council. I can see nods from Dr. Williams. And just to confirm, Mr. Kelly, that
yes,
is also...
that's fine. That week is fine.
That's fine, just before we pin things down and then realise that there's an issue there. Okay, just... I'm assuming from the discussion that parties have full availability for that week, on the assumption we'd actually be starting on the Tuesday, and the council not being available on the Friday. But beyond that, are there any other specific dates? Obviously, there's been suggestions made, but are there any dates when any particular witnesses or parties are not available that we need to be aware of in terms of our time?
We can make that week.
Okay, thank you. I think that's everything. So just to recap, we're agreed, I think, on an inquiry on landscape and visual, hearing sessions on policy matters, community issues, planning conditions, and we'll take away the request for a further session on fisheries matters. So the note of the meeting will confirm the sessions and the intended timetable. Any further comments, clarifications on that before I move on to discuss arrangements for documents, item 8? Nope. Okay. So item 8 on the agenda, just to run through core documents as set out in Appendix 3, and I'm sure the parties are familiar with this. We would prefer to work to a single core documents list, which is managed by one party, usually the applicant or the planning authority. We would request the cooperation of other parties in preparing this and making documents available in accordance with the agreed timescale. We'll come on to timescale in a moment. For clarity, particularly for the benefit of parties listening who have not participated in this type of process before, a document could be any report, plan or photograph that any party intends to rely on in its evidence. Given the security risks associated with the use of USB storage devices, DPA no longer supports their use in managing core documents for inquiries. Instead, we can set up a workspace in the file transfer tool Objective Connect to allow document transfer. This allows parties to easily view and download documents, and our IT and casework teams will ensure participants receive sufficient guidance on how this will work. Documents will also be available on our public website for anyone to access. So can I just ask, is the applicant content to manage the core documents list?
Yeah.
Yeah. Are other parties content with this approach? Any comments? Yeah, everybody happy? Okay. That's useful, thank you. So moving on to the timetable for submission of documents. An indicative series of dates was set out within Appendix 3 of the agenda, and our note of this meeting will set out the finalised timetable taking account of discussions today. Before inviting comment, I would highlight that having reviewed the provisional dates further since the agenda was issued, there might be scope just to simplify the timetable by adjusting certain dates a week or two so that they coincide with other dates, just to reduce the total number of different dates. So in particular, the draft core documents list could be adjusted from the 1st to the 8th of June, which is the suggested date for draft conditions, and the deadline for inquiry reports to be submitted could also be brought into line with the suggested date for finalising core documents 6 weeks before. So other than those comments, and rather than go through each of the individual dates, I'd just like to invite comments on any areas where parties consider proposed dates leading up to the sessions might need to be adjusted further.
I think there's a general observation. Obviously, we'll do what is asked of them, but they're very early, given that this is a session for the end of October. So dates in June feel to us to be rather premature, and I'm sure there's no prejudice to anybody if they were going to be pushed back, by a month or so. So I think it's a general feeling that June dates can go back by a month or so, even 6 weeks. Will still leave 2 or 3 months before the session.
Other parties have thoughts on that?
Yes, I mean, I tend to agree with Mr. Hardy. I wasn't quite sure. Perhaps I can ask you, sir. I'm not quite sure I picked up correctly what you said about inquiry reports when you were.
So I think they were noted on the provisional timetable as 8 weeks before the inquiry, and I was suggesting that could be adjusted to be 6 weeks before, which was the date that core documents were suggested for, just so that there's a common date there.
Yeah, I very much agree with that. I was going to say 4 weeks, but 6 weeks before is fine. And the other matter I was going to say, the statement of agreed matters, you can tend to get quite a lot of agreement on that early on, but to finalise it and get it as useful as you, I would suggest that about the same time as when inquiry reports are to be put in, because everybody's concentrating their minds on what's agreed and not agreed, or maybe a week before then if appropriate, or 2 weeks before then. But that's the one I would suggest in particular that might be pushed back. But generally, I would agree with Mr. Hardy that we're going to be ready in good time anyway, and the dates could be pushed generally back.
I think I agree with that, obviously. The only thing I'd say with the statement of agreement is it would help to have some time between the date for that and date for reports, because the purpose being to agree things that you then don't need to cover up the reports. But that could all be sort of August time, because that will allow sufficient time. So a couple of weeks before reports, yes. 6 weeks before that, you'll take it. I haven't done the date. I haven't looked at the date. August sometime. It's not the biggest, given the issues. It's not. This is not the biggest inquiry that you get with these types of schemes. So I think we're absolutely comfortable in terms of being able to reach things. June feels very, very premature.
Okay, that's noted. Other parties, Mr. Kelly, any comments?
I would agree with the comments made that I don't think we need to be putting things in June for the end of October inquiry. I think we have a good lead-in time. So generally, I would just support what's been said.
Okay, thank you. Dr. Williams, anything to add?
No, I think the comments have all been sensible.
Okay. Any other dates that anyone wants to mention specifically before I move on? I'll just touch briefly on closing submissions at this point. We would expect those on the whole case to be submitted in writing rather than as part of the inquiry or hearing sessions. We can finalise the timetable during the inquiry, but for now we would anticipate that for the council and other parties, they would be submitted 14 days after the final day of the oral sessions, and for the applicant, they should be submitted within 21 days. But we can finalise that at the inquiry itself. I should say here, sorry, Mr. Harding.
No, I didn't. I thought you finished. You go.
So just for the benefit of individual parties watching the webcast of this meeting, I would say it's normal practice for individual parties to rest on the representation. Would be entitled to provide a closing submission if you wish, but you should not feel obliged to do so if your points have already been covered. And just moving on, another matter to touch on in terms of summaries of case. Some of you may be aware that DPA has been trying to speed up the process of writing up reports for ministers. So as part of that, it would be extremely helpful if parties could summarise their case, particularly in this case, if the witnesses for the landscape and visual elements could provide summaries of their cases. And we would then use this as the basis of the summary of your case in the report itself. And that might work best as part of the closing submissions. Are there any comments at this point on closing submissions or summaries of cases?
He was really dealing with that point. A very recent example, one that we just finished a couple of weeks ago, where there were selected topics, not dissimilar to this. There was an L&D session, and then there was a hearing session on policy, and then there was another session on another topic. What was done there was closing submissions on both the inquiry and hearing topic, but not on all of the other issues. It wasn't an all-encompassing closing submission from the applicant, but there were full submissions on all topics that they've got further proceedings, and then case summaries on those two specified topics as well. So I don't know whether that's what would be envisaged here. What I don't think is helpful is having an all dancing closing submission on topics which have not been subject to further procedures. So my proposal would be closing submissions, L&D, policy, potentially fisheries, potentially some of the community issues, limited to that.
Okay, that's noted. That's useful. As I say, we'll probably make final arrangements at the sessions themselves, depending on where we've got to on that. Any other thoughts on that point just before we move on? Any other party want to come in?
I would agree with that. It's much more helpful to focus the submissions on the issues that are in dispute.
Okay, that's noted. Nearly through the agenda. Item 9 is in relation to site inspections. Both Haywood and I intend to carry out unaccompanied site inspections during the summer, most likely in August. We'll visit a number of the viewpoints and locations referred to in the application, consultation responses and representations. At this stage, we've not identified any locations where we consider an accompanied site inspection may be required. If any are required, we could look to schedule these during the week of the inquiry and hearing sessions. At this stage, if parties consider there are locations we should visit that would require us to be accompanied, we would request that these are suggested to us in writing within 14 days of this meeting. Alternatively, if you don't consider that any accompanied visits are required, please also confirm that to us. But I'd like to invite any comments on whether there are particular locations that the parties consider we should visit as part of our unaccompanied site inspections. Anything in particular to draw to our attention?
We've got a list we can come up with, and that can be typed up or put in into a graphic form for you. But the list that we've got so far is BP2, that's Rosewell Bridge. Then a sequential look at the A837. We think that viewpoint 1, viewpoint 4, viewpoint 9. Viewpoint 7, that's the A839 Rosewell Leg Road. Viewpoint 5. Sequential look then at the A837 Rosewell Leg, and that's VP3, VP8. So I think that actually is taken a little bit out of order, but that's VP1, 2, 3, 4, 5, 7, 8, and 9. Those are our suggested.
Okay, thank you. That's helpful. Any other comments from the council on that matter?
I think we've heard Mr. Hardy's list. If we want to suggest others, we might add those within 7 days. We can have a quick discussion with Mr. Kelly.
Okay. Any comments, Mr. Kelly, at this point?
Not in relation to unaccompanied site visits. On the accompanied site visit, I would suggest that your visit to the river environs, the fishing pools and the fishing interests should be an accompanied site visit with Dr. Williams and probably the fisheries manager, Steve McKenzie, who undertook a similar accompanied site inspection for the Caplick wind farm inquiry some time ago. So that would be the main suggestion for at this stage.
Okay, thank you. Dr. Williams, do you want to add anything to that?
Yes, I would agree with that previous statement. I think it'd be very useful to have a look at the river itself and that location.
Okay, thank you. That's helpful. Are there any access issues that the parties consider we need to be aware of at any particular locations? I'm thinking of the unaccompanied visits here. No, Mr. Kelly.
I was up there just a few weeks ago. There are live timber extraction operations on the north side of the Strath just now, which might limit your access to some of the paths or tracks that you might want to look at the site from. But it's just something to be aware of because it's an ongoing operation and some of it may have been finished by the time you go. But there are certainly timber extraction works on the north side of Strath Oykel just now.
Okay, thank you. That's useful. Any other comments on site inspections before we move on? Okay. Item 10 on the agenda, just a few miscellaneous items. The DPA contact, as you're probably already aware, Audrey Devoy is the DPA case officer. She'll be your main point of contact during the process. She'll be liaising with me and Ms. Haywood as necessary and ensuring documents are circulated or made available on the website as required. Just to confirm that, as already mentioned, we will be issuing a note of this meeting, and subject to other commitments, we're hoping to be able to do that within a week after today's meeting. So finally, item 11, just picking up any other matters. Is there anything else that anyone wants to raise that we haven't covered already? No. Ms. Haywood, anything you want to add at this point? No. Okay, in that case, I think we have come to the end of the meeting. I would thank you all very much for your participation in the meeting, and we'll see you all in October.
Thank you.
Thank you very much. Goodbye.
Thank you. Goodbye.